And we are back here on the show. Well, if you don't know, social media has become an important tool to connect with one another and as a means to promote one's business ideas. Visibility of products or services is just a few clicks away on the internet. However, social media networks pose a challenge for trademark and copyright laws. To protect your business's social media and beyond, you should understand the importance of registering for federal trademark protection and copywriting your intellectual property. Joining us now to tell us and share a little bit more about this and to continue in the conversation is the partner at Toomey, Latham, Shea, Kelly, Dubin, and Quartararo, LLP, Catherine Dowley. And thank you, Catherine, for being with us.
Good morning. Thank you for having me. Glad to be back with you.
Yeah, good to be back. And, last time we were talking a little bit about copyrights and trademark. And we talked a little bit the last time about this one thing that we had to pick up on, which was social media. And when we look at social media, so many people are on social media. And I watch, whether it's Instagram, Facebook, you can see pictures, you can see things, and people will take them and make them their own. And we know that legally, this is a big no-no.
That's right, Darren. It's a big problem today because of everyone being on social media. And I think, as I mentioned the last time I was on, just because something is out there on the internet doesn't mean it's for the taking. Not anybody can just go and grab a picture from a website or Insta or anywhere and use it for their own uses. That is called infringement. So people need to be very, very aware of that. There are two different things. There's copyright, which would apply to photographs, articles, original works of authorship, and then names. And names are trademarks, whether they're registered or not. You can't use somebody's brand name to, for instance, as a link or as a search tool, okay? Sometimes people will, if they're optimizing their search capabilities, they use keywords. And sometimes people take names or brand names and use them as their keywords for getting people attracted to their website. That's not legal. You can't use somebody else's name to bring people to your site. So there are several different things working in the internet and social media age that are fraught with the possibility of trademark and copyright infringement.
So I guess now if somebody's out there and they're saying, listen, I got good product, I have intellectual property, and I'll give you a chance to explain intellectual property in my next question. I've got this intellectual property, but I need to protect it. What are the ways or what are the steps that need to be taken to protect one's intellectual property? Better yet, what belongs to me?
Okay. Intellectual property is comprised of copyrights, trademarks, and patents. Patents are inventions. Copyright, as I mentioned earlier, is an original work of authorship, such as taking a photograph, a poem, a song, and writing an article. And trademark is a name or a logo which indicates the source of the product or service. So there are various ways to protect your intellectual property. And if you have a copyright, you can apply for a copyright registration with the United States Copyright Office. If you have a trademark, you can apply to the United States Patent and Trademark Office for registration of your trademark. And if you have an invention of some kind, you can apply for a patent. There are different applications, different nuances, and each take a different amount of time. However, there are common law rights associated with your intellectual property, meaning that you don't need to have registration of your copyright or of your trademark. However, there are many, many benefits to registration, and you should register if you can, because not all what you may think is intellectual property is protectable. For instance, I mentioned the last time in the trademark arena, descriptive names are not protectable, such as, I think I mentioned the last time, the example Riverdale Dry Cleaners. That's a descriptive name that would not be capable of trademark protection. But if you do use a suggestive name or an arbitrary name, and you're branding that, you do have common law rights. So you are somewhat protected.
Yeah. I want to talk for those people who may not be so familiar about penalties, because listen, with these things come consequences and penalties. What are the potential consequences and penalties if someone does take pictures, copyright infringement, trademark infringement? What can a person be looking at?
Ooh, depending, of course, on the severity and whether or not they're obtaining economic benefit from the use of those items that they've taken without permission, they could face a lawsuit for infringement, which would include if the copyright was registered or the trademark was registered, statutory damages. They would have to pay the other party's attorney's fees, and they'd be sued in federal court. So there's a lot at stake. And I always tell my clients, when in doubt, ask for permission. Because a lot of times, owners of copyright will allow uses of their material for certain reasons. But if it benefits the user economically, then permission probably will not be granted. So you can't just take what you like without paying for it. You should ask for a license or license to use or permission.
Very simple instructions. For some, not so easy to do. Catherine, thanks so much for being with us here on Open.
Thank you so much for having me, Darren. Great to see you.
Great to see you again. And always, if you want to find out more information about Catherine, the work, trademarks, copyrights, all you got to do is go to suffolklaw.com, suffolklaw.com, and there you can find out more. And I'm sure Catherine will be glad to help you out. All right. Listen, taking a quick break. We got more show. Don't go anywhere. Open continues coming up right after this.